And this thing, oh, this is on.
Yeah, this. Hello, everybody. Welcome to this workshop, to the session on the legal nature of carbon credits. Are people settled? Yes. My name is Flavia Rosenbusch. I'm with the World Bank. And the main purpose of this session is to share with you what we think we should be looking at when we look at the legal nature of carbon credits. What are we trading? Why is that important? And where should we be focusing in order to provide certainty around the legal nature of carbon credits? In any market, we do need certainty around the property rights. We need to know who owns the thing we want to trade. We need to have trust. We need to have a marketplace to trade that thing we want to trade. In this session, we are going to be talking about those property rights around carbon credits. Why is that important? Because we need to know who owns the thing, how do we trade that thing, how do we create security over it, what happens in case of insolvency, what happens in case of expropriation. At the World Bank, as you all very well know since you're here, we believe that carbon credits are an essential tool in the path to decarbonization. We have been providing support to developing countries, to emerging economies, to help them in that decarbonization and the low carbon path. One of the issues that has been coming up over and over is, what are carbon credits? What do you think we should make out of carbon credits? Should these be commodities? Should these be securities? Are we talking about authorization? And that is important because the legal nature of the thing is going to determine the regulatory treatment, is going to determine the accounting treatment, is going to determine the tax treatment of it. So I'm very happy to be able to present to all of you an initiative that is being led by UNIDROIT, which is an international standard setter for private law, and by ISDA, that, as many of you will know, is the International Securities and Derivatives Association, where we will be working on a project to come up with general principles around voluntary carbon units. Why are we focusing on voluntary credits instead of focusing on compliance credits? Basically, because voluntary units and compliance units have a number of things in common. The main differences between voluntary units and compliance units is that compliance units do not have corresponding adjustments, and compliance units cannot be used in compliance markets. But, voluntary units cannot be used in compliance markets. And voluntary units do not carry corresponding adjustments. But both voluntary units and compliance units will need to carry high integrity. They will need to be measurable, permanent. They will need to avoid double accounting. And they can both be used in voluntary markets, which are the markets that, as we all know, are growing at this particular time. So we will be using both voluntary and compliance units in voluntary markets, and we know that is one direction that the European Union is taking, and so is Germany in particular. They would like to see their credits including corresponding adjustments both in the voluntary market and the compliance market. I have the pleasure to introduce you to Peter Werner, who is a senior counsel at ISDA, who has been working on the legal nature of voluntary carbon credits for some time, analyzing some particular jurisdictions, and who will share with us the work they have been undertaking. Thank you, Peter.
Thank you, Flavia. Thanks, everyone, for joining our session today. Does the mic work? Okay, thank you. So, yes, ISDA's work, ISDA is a global trade association, so we are just that. But one very relevant, in terms of markets, relevant aspect of our work is to provide a standard trading documentation for all kinds of underlying assets in the derivatives markets for cross-border use. And given the fact that voluntary carbon credits have become so important over the recent 2.5 years, I would say, as far as ISDA is concerned, we thought we need to progress this in the wake of certain policy decisions that have been made. I'll get to that in a second, but I want to highlight the second leg of ISDA's work in this space, and that's the publication of legal opinions for industry that market participants across the globe can use for their legal due diligence services. And the second reason is the main one for the huge interest within ISDA in the topic we're discussing today. What is the legal nature of carbon credits? So just to recap briefly what led us to this, policy, when I say policy decisions that have been made in light of the climate urgency, I'm referring to discussions such as what has happened within the VCM project, which concluded, or had one of the conclusions, directed at industry to produce general trading documentation, general terms and condition-like kind of documentation. And that's a call to ISDA and similar associations, IETA, for example. So we have started and have finalized production and publication of that kind of documentation. I'm not going to talk about this. But when we started this process, we thought it is equally relevant to be clear about the degree of legal certainty around voluntary carbon credits in particular. Because we had the view at the time, we established the view that there is not much legal certainty around voluntary carbon credits at all. Unlike with other types of underlying assets that you trade using normal types of trading documentation. For example, in the commodity space, several other types of environmental products, you can think of conventional commodity products as well. There, at least, I have lots of legal and regulatory underpinning helping the product. In the space or the area of voluntary carbon credits, there's no such thing. So therefore, market participants, if they want to use this type of product under the same parameters for their trading documentation, they need to be sure what the legal nature of the thing is that we are trading. And this is in particular relevant for insolvency law purposes, which is the main topic of the industry legal opinions that we publish, for example. Can I, in case of the insolvency of my counterparty, can I, and this is getting technical now, I'm not going to go into too much detail, but can I net voluntary carbon credit transactions equally easily under a national legal system as any other type of asset that I'm trading under the same type of documentation? And this, because this is an insolvency law issue, needs to be determined based on the jurisdiction where the counterparty is located. So this is not something I can agree on easily by just saying this is the governing law of the contract and that I don't need to think about any other law. It's not the case. So therefore, we thought it might be helpful to the development of markets, in particular if the aim is to scale voluntary carbon markets in light of the urgency of the climate challenge, that this issue, the legal certainty issue around voluntary carbon credits, which we call VCCs, it's a little easier by way of acronym, if legal certainty can be enhanced. And in order to provide a starting point for the discussion, we've done we've published 2 papers, legal papers, that try to get to the point under 6 different jurisdictions, legal regimes, as to find out what these voluntary carbon credits are under these 6 different jurisdictions and legal systems. The US, the UK meaning England in this case, Germany, France, Singapore, and Japan. And if you'd like me to elaborate a bit on the outcome of this, it is not clear in several jurisdictions, and it's a little bit clearer in others. We've chosen these 6, more or less. These are obviously, you could say they're random, but we have thought about the size, the potential size of the markets, and also the existing activity around compliance markets in this case, in these jurisdictions, and future plans also with respect to voluntary markets. So that's our selection. It's kind of hard to choose out of 190 different UN member states, the relevant jurisdictions. But these are, as far as trading is concerned, and expected trading, these are certainly significant jurisdictions. And for example, in jurisdictions that are similar to the English regime and legal tradition, the view seems to be that these voluntary carbon credits, which have no statutory underpinning at all, but they could be, under common law principles, regarded as intangible property, for example. That's already a good analysis that helps you in going further, because I know if it's property, it's easier to take security over the thing. It can be stolen or hacked or phished, etc., and then there are certain consequences. In other jurisdictions, it's not so clear, often because it requires a statute, and obviously this being a new product compared to others, this poses a challenge, in particular if I have a statutory requirement to legislate for everything. So these 2 papers have been published. You can get them on our website or by contacting us, but the idea was to help further in the discussion, in particular among global legal standard setters, such as UNIDROIT. So one appeal or suggestion in the paper that we make is that a global legal standard setter take up the suggestion to clarify the legal status of voluntary carbon credits from various angles, property law, insolvency law, conflict of law rules, for example, so that the jurisdictions around the globe going forward benefit from some guidance when it comes to their policy decision at national level to establish the relevant legal and regulatory framework to establish these carbon markets. And given the fact that most of the credits, VCCs, that are needed here will be generated in emerging market jurisdictions, this added a particular urgency to the request as well. And going forward, we hope that when this progresses, that multilateral development institutions like the World Bank and others can advise their client countries in a certain way to create such a market. One final point, if I may, on this. What we are not suggesting as industry is expressing a preference which type of national regulator should be dealing with carbon credits. So this discussion is only about what is the thing that I'm trading. We are not discussing who should be regulating this, because that's up to every jurisdiction as well. It gets often mixed up in the debate. That's also a discussion among standard setters, which is of a non-legal nature. This is more in the regulatory policy space. So, for example, I4C is looking at this kind of thing. So we're not saying it should be the central bank, it should be the SEC or somebody else dealing with carbon markets. All we need to know as trading counterparties is what is the thing I'm trading and what's the legal nature of that credit. So maybe I should stop here.
Yeah, thank you so much, Peter. And just building on what Peter was explaining, we found, as I mentioned ourselves, being asked by our client countries, what is this thing? How should we also regulate it? How should we deal with it? And as the World Bank, we're not in a position to tell any jurisdiction how they should qualify legally an asset, because it will depend on a number of things, including their national legislation. There's, as Peter mentioned, there's common law countries, there's civil law countries. Therefore, legal treatment is going to be very different depending on this jurisdiction. So we were very happy to support the initiative led by UNIDROIT and the enthusiasm to say, we have looked at digital assets, and they have just recently published general principles on how to treat digital assets, and we would be very excited to look at voluntary carbon credits. So it is also my pleasure to introduce Professor Ignacio Tirado, who's Secretary General of UNIDROIT, and maybe you can share with our audience what the project on VCCs will include.
Right, thank you. Thank you for the invitation. Thank you all for being here. It's a pleasure for me because, although most of you are not, I am actually from Spain. So it's very good to be here. I particularly appreciate that possibility. In a way, I could be said to be the odd person out in this panel, meaning our organization, although it's related to and supports, of course, and goes in the direction of supporting sustainable development, is not an organization that does work on environmental matters, but rather is pure private law, very technical matters that we have been dealing with for almost 100 years. So allow me to say UNIDROIT, which is the International Institute for the Unification of Private Law, was founded in 1926. So it preceded the United Nations. It was founded in the context of the League of Nations, which is the organization, the first attempt at a global scenario. It has currently 65 member states, which account for 75% of the world population and over 90% of the world GDP. So representation is global, and it's fine as it is, because when it becomes much larger, it becomes much more difficult to maneuver and to handle. So the work that we do really is work towards the drafting of standards that are extremely technical and useful in the market. And in this area, as Flavia just mentioned, we've just finished hand in hand with the Uniform Law Commission of the United States, the Law Commission of England and Wales, the IMF and other organizations, an instrument that sheds light on how to treat, how to deal with, how to use digital assets from a purely proprietary standpoint. So we're not doing work on regulatory topics or on public law concerned matters, but rather the purely technical regulation underpinning the use in the market of these instruments. And for that, there was nothing in digital assets, and to the best of my knowledge, always very limited. There is nothing for VCCs either. So when ISDA approached us, and also with the enthusiasm of the World Bank, we thought it would be a very good idea to start a project which would seek to shed more light, therefore provide legal certainty as to what voluntary carbon credits are, and do it in a way in which this analysis of what voluntary carbon credits are is linked with the, for example, the voluntary carbon markets and its different typologies. So we analyze separately primary markets and secondary markets. We'll also take into consideration forms of carbon offset project financing schemes as well. So the idea is to identify those areas where there is a need for certainty, especially in countries of the global south, which might need a little bit of help in identifying some of the more difficult technical questions, and move forward. So the legal nature, in principle, we start in the project now with the World Bank, ISDA, and many others, would be to move in different stages. The idea would be first to give it a first go at trying to ascertain the legal nature, but we won't get lost in abstract, theoretical, academic constructs, but rather whether they are a bundle of contracts or they are themselves an asset, as you want to call it, or security. But rather, we purport to follow the approach we had for digital assets. No one really knows what they are either, if you think about it. This is not really anything. It's the possibility to transfer something or to do something with something. But what that something is still uncertain. So the idea is to use a functional approach and to treat voluntary carbon credits in a way functionally as if they were apt for being traded. They were apt for being subject to security interests. As if they were apt for being transferred in more complex schemes. So that is the type of analysis that we purport to conduct, which would mean analyzing creation, transfer, fungibility, collateralisation, what happens in case of insolvency, as was mentioned before, of the either of the person holding VCCs or the intermediary holding them for or on behalf of others, which of course creates quite a lot of additional troubles. Perhaps out of our first encounters, one of the initial conclusions in terms of methodology would be to observe and to produce an analysis of the problem looking at the entire life cycle of the voluntary carbon credit. So looking at its issuance, at its verification, transfer and trading, and ultimately, if necessary, its retirement. Anything, however, let me insist, concerning private law, which is something you might have not seen elsewhere. Another item which we purport to have a look at is registries, because we are a standard setter in terms of registries, not this type of registries, but rather the type of registries that you use to deal with, for example, securities or intangible assets when you want to trade them or when you want to use them as collateral for access to finance. These registries are different to the plentiful registries that exist in this scene, which are between themselves completely uncoordinated, with different rules, with no interoperability, with very little consistency, and therefore that becomes really unuseful because it increases substantially transaction costs because there is no legal certainty. So coming up with some sort of baseline rules as to what constitutes best practices in terms of the use of registries for VCCs is something which could be useful also in light of existing problems concerning access to data, double counting, blah, blah, blah. So those will be important parts. As to secure transactions and collateralization of VCCs, we'll follow close what we did with digital assets. Actually, there's no reason probably to depart from the conclusions and the approach had for digital assets, but we are aware that not all VCCs will be in the form of a digital asset, and therefore we'll need to find analogies to other types of intangible elements which are not in the form of digital assets. For that, to the extent that we are in that area, things become easier because for that there's long-standing set of standards in the area of securities and bonds and trading in international markets. So we purport to cover both when they are digital assets and when they're not. But when they are not, it will be much easier to just refer to existing standards. We will analyze custodians, intermediaries. One of the problems now is that there are plenty of intermediaries, brokers of certain types, but it's not always clear in which capacity they act vis-a-vis the asset, the voluntary carbon credit. It's not the same when the intermediary holds title to the asset as to when it merely has a contractual right to do something with it for the owner, that changes completely the legal situation of that VCC and the holding. And in case of default in payment of an obligation, let alone in case of insolvency of the holder, things change quite a lot. So, and if that is in the area, and if the VCC is actually a digital asset, then it becomes still more difficult because that presents uncertainties which have had to be dealt with in a different project. But fortunately, we did it. So we'll analyze the issue of the different granular analysis of the holdings by intermediaries of VCCs going forward. I'm sure as we pull the rope, we'll find more things, more complicated matters that will arise. To the extent that we can, we'll solve them with a group of experts representative of the entire world. And of course, at some point, we'll have to deal with the word no one wants to deal with, which is insolvency. What will happen when the holder of the VCC falls insolvent? Is that property? How is that going to be identified? How is that going to be handled by the insolvency practitioner? Which creditors have an access to that VCC in repayment for, let alone when there are derivatives attached to those? What happens in case of the insolvency of the intermediary and custodian? We've, again, done a little bit of work. We started out, but there's plenty of work to do, fascinating from I know it sounds odd, but it will be fascinating from a technical standpoint. And the whole idea is that this project that we're doing together with many other organizations will underpin these voluntary markets and allow them to grow and to reach economies of scale and benefit the Paris Agreement. So we are all on the same boat, hopefully. You will indulge me there. So that would be an initial description of.
Thank you. Before going to open it up to see if there's any questions in the audience, Ignacio, I would ask you if you could elaborate on what instrument is going to be the result of our common work and what other instruments we could have used under the models developed by UNIDROIT when you provide standards.
Right. So UNIDROIT as a standard setter is one of the three sisters, together with the United Nations Commission of International Trade Law and the Hague Conference on Private International Law. We normally work on either hard law instruments, treaties, conventions, which on its face would seem quite difficult to reach here because you need a lot of political consensus to go down that route, and it takes a lot of time. So more likely we would be moving towards some sort of standard setting set of principles, or maybe a model law, which is still soft law, because it's just there for countries to adopt it if they want to. I would like to say to you, and I mean to, I'm pretty honest with this, my organization, the UNIDROIT, but also UNCITRAL and The Hague, tends to have the ears of legislators in many countries. So when we produce one of our instruments, they're normally or very often taken into consideration when legislating locally and nationally, even regionally. And I think, of course, our instruments are drafted receiving input from everywhere. That's what gives them the legitimacy of being a global instrument. So let's say this might be especially interesting in the southern part of Africa, where no doubt there will be experts from that area that will be providing regional input or local input as to the specificities that might be required there. So it could be useful. Soft law, model law, or principles would do, so long as it has an explanatory part, which is always very useful for legislators, because otherwise it might get too technical. So, I think this would be more or less the different options. But of course, the World Bank will have a say as to what is more interesting.
Thank you. Thank you so much. So I'm going to open it up for questions from the audience, because we have barely 10 minutes left, and it would be great to hear from you in case.
Someone in the back, I think.
Thank you. I have a question or a thought. I understand that basically the perspective is very much dependent on the use case, and you're taking recourse on in your assessment in digital assets. Now, looking from a originating country perspective and also hearing the discussions in the negotiations around markets, I would tend to believe that originating countries would look at it rather as a resource than a digital asset, and also which would basically mean that originating country jurisdictions would have a different set of regulations than the countries that would use VCCs in trading. And how do you see consistency across the line of custody from the originating country to the trading country, basically, for example, when it comes to things like VAT or other taxation issues?
So acoustics are, when you're up here, are very, very bad. So let me make sure we heard your question correctly, because there's echo and there's another hand up. Oh. ¿Qué?
¿Qué le has pedido que lo haga de nuevo? ¿Qué pregunta?
Le iba a resumir yo.
Ah, sí, sí.
Sí. So there's a hand up for another question or to clarify the question?
For another question.
Okay. So if I understood your question correctly, is on digital assets and the result of the work undertaken by UNIDROIT already and conflict of law? No? Would you mind standing up and repeating your question? It's very hard to hear.
Yes.
Sorry, I'm really sorry for
so
that.
Please stand up and talk loudly.
Yeah.
Yes.
So the question is, originating country would rather look at VCCs from the perspective of a resource and not as a digital asset, because they're not very keen in like the trading part, but rather in looking at it as a resource of its country, for example, forests or whatever. And therefore, I would assume that originating country, when it comes to regulation of the asset or the title, will look quite different from the jurisdictions that use it in trading, which will probably give a rise to discussions around VAT, cross-border, and other taxation. And how do you see in your study a consistency across the line of custody in terms of legal nature and taxation?
Thank you so much, and sorry for that.
Yes, I can try and address aspects of this. Thanks for the question, and it goes back to what we mentioned earlier. There's a necessary delineation to be done here in the scenario that you have outlined. But what is common to both of these scenarios, generation of the VCC and then trading further on, equally relevant to both worlds, if you like, is enhanced legal certainty around the legal nature of the asset that we're trading. It doesn't matter what the regulatory treatment is of a carbon credit that gets generated in a marine conservation project somewhere further down the line, 8 counterparties further down the line. It is equally relevant at the outset of the project, that the project developer knows what the legal position is in the credit that originates from their project. That's the same legal nature question at this stage as it is further down the chain of trading. And this is what the project proposal is supposed to cover. It is distinct from the question as to what is the regulatory treatment of a credit that got generated somewhere 5 years down or 5 counterparties down the line, we are not dealing again or still with the originator, but with simple trading counterparties or somebody who wants to retire the credit. So that's why we keep saying that the regulatory treatment and the classification of these VCCs is a different issue from the one the project is trying to address, which is the legal nature.
May I add to this? So, sorry, I had completely misunderstood your question. It's very good. I didn't try to answer it. Now that I see, and thank you, is indeed very relevant. Just to underline the fact that we are not going to be going into whether or what systems should look like when they determine that someone has earned a voluntary carbon credit. That's a regulatory, and it's for each country to determine. What we'll do is, say you have a VCC, and you want to trade with it, and you want to use it as collateral, we will provide rules to help you, modern, efficient rules to help you do that, even cross-border. And the nice part of it, to complement what was just said, is that the more clear what the VCC is, the more likely it is that it's going to be traded. If it's going to be traded across borders, that creates a push upwards towards improving standards for the issuance of these, or for the certification of these VCCs. Because the moment 10 countries have a number of requirements which are adequate for the certification, and they start trading easily between themselves based on these rules, if an 11th country wants to come into the club to get financing, it might have to, even though the rules would be the same, the fact that this VCC might not be up to the regulatory standards of the others would make this country probably move towards a baseline minimum requirement type of certification standards. So by improving the functioning of the market, you enhance the likelihood that the regulatory public side will be improved as well. Otherwise, there will be no legal certainty, people won't trade with it.
And just to add, this project, this joint project will not look at taxation, it will not look at regulatory aspects around VCCs. IOSCO, as Peter mentioned, which is the regulator of financial markets, is also looking at how to regulate or how to look at VCCs from a financial market regulator's point of view. And we are coordinating with IOSCO so that both efforts bring fruits in a coordinated manner. So the project we are talking about today is going to look at the private law aspects of VCCs, and hopefully the project that is led by IOSCO is going to take a look at the regulatory aspects of voluntary carbon markets. Maybe we can take just one very quick question, and I am being told we need to wrap up. So let's go to that question quickly. Not at all. There's a lot of echo up here, sorry.
My name's Nicholas Steen from Encompass. It's a bit left field, but are you considering, when you make the regulations, that what we're trying to do is reduce global emissions, and really this is all a construct, what we've created, these emission reductions, verified emission reductions, OCUs, what are all the different acronyms that people, in fact, OCU was a new one that I found today. I think that's right. Maybe it's something else, COUs or something. VERs, CERs, EUAs, all these different things. But what we really need to be doing is reducing emissions. And if I am an entity that is trying to do that, if I'm taking responsibility for my emissions and I invest in a project, I don't actually need those emission reductions in my back pocket. So whilst, yes, there are VERs and there are corresponding adjustments, there's also, I think it's really important that there's still opportunity for people, entities to invest in making sustainable change happen. And you don't actually need the emission reduction in your back pocket, but you could calculate the reductions. Do you have any comments on that? So I know you're focused
No,
on
absolutely.
narrowing it down, but I'm trying to open it up. Thank you.
Absolutely, and as you know, the World Bank mission is to eradicate poverty, to share prosperity in a sustainable manner. So our mission is to help developing countries reduce emissions and to help them towards a low carbon path. One of the tools, just one of them, are carbon markets. And in this particular project we are presenting today, we're hoping to provide certainty around legal nature of VCCs to create more robust, high integrity carbon markets. Thank you very much to everybody. It was great to have such a busy, full audience. We didn't think there was going to be so much interest. We're going to be around if there's questions. Thank you so much, everybody.